Welcome back to the channel. Today we're diving into a major development in the legal saga of former President Donald Trump. On July 15th, Judge Aileen Cannon has dismissed the entire classified documents case against him, citing constitutional grounds. Let's break down what happened and why it matters and what it means going forward. On July 15th, U.S. District Judge Aileen Cannon dismissed the classified documents case against former President Donald Trump. The case involved allegations that Trump illegally retained highly sensitive state secrets after leaving office and obstructed government efforts to retrieve them. The indictment says that Trump was personally involved in this process. Judge Cannon ruled that the appointment of Special Counsel Jack Smith violated the Constitution. Judge Cannon, appointed by Trump in 2020, found that Smith's appointment was improper because it was not based on a specific federal statute and because he had not been named to the post by the president or confirmed by the Senate. Judge Cannon's ruling states that no legal authority gives the Attorney General broad inferior officer appointing power or bestows upon him the right to appoint a federal officer with the kind of prosecutorial power wielded by Special Counsel Smith. She also noted that Congress had not authorized appropriations for the expenses of Smith's office. This ruling all revolves around the Appointments Clause of the Constitution, which allows the president and department heads to appoint certain officials without Senate consent. That is, if Congress grants such power through a law. Special counsels, considered inferior officers, typically fall under this clause. However, Judge Cannon found no corresponding law authorizing Smith's appointment, claiming it effectively usurps a power vested in Congress. As some of you might remember, and I certainly do, the special counsel's appointment stems from the Watergate era. Back then, special prosecutor named Archibald Cox played a crucial role in this debate. Cox oversaw the notorious Watergate investigation and Nixon's role in the cover-up. Nixon's downfall, due to his attempted firing of Archibald Cox, led to the passage of the Ethics in Government Act of 1978. This act established specific guidelines for independent investigations into wrongdoing by members of the executive branch that might seek to influence the outcome due to their political power. In December of 1992, the Ethics in Government Act expired due to Republican filibuster, drawing cheers from longtime critics and opponents who decried the supposed excesses of the Iran-Contra investigation, and because they felt that conflicts with an independent counsel had unfairly pushed out their president. However, Republican congressional critics of the new Clinton administration soon began to see the value in reviving this law. They hoped to use it in the emerging Whitewater case, which was being investigated by Justice Department appointment Special Prosecutor Robert Fisk. In February 1994, a Democratic congressman sarcastically noted the, quote, miraculous conversion of the law's former critics. However, in 1994, Bill Clinton renewed the act for 5 years, not thinking that the law might someday apply to him. How things change. By mid-1998, the Clinton administration faced 7 separate investigations. We all remember Kenneth Starr, who replaced Robert Fisk in the Whitewater investigation. As the 90s went forward, support for independent counsel waned among lawmakers, and the Ethics in Government Act expired on June 30th, 1999. Upon the law's expiration, the Justice Department, under Attorney General Janet Reno, established procedural regulations for appointing special counsels. That same year, Reno utilized these regulations to appoint John Danforth as special counsel to investigate the FBI's handling of the Waco siege. Then, in December 30th, 2003 and February 6th, 2004, during the George W. Bush administration, Deputy Attorney General James Comey appointed Patrick Fitzgerald as special counsel to investigate the Valerie Plame affair following the recusal of Attorney General John Ashcroft. Because the independent counsel statute was no longer a formal law, but lay within the murky realm of regulation, Judge Cannon was able to pounce on it and declare that the entire edifice of the legitimacy of the ordinance was unconstitutional. According to most experts, her ruling single-handedly rewrites decades of legal precedent, including Supreme Court decisions that had upheld the independent counsel statute. Georgetown law professor Steve Vladeck summed it up in a tweet. In 1988, the Supreme Court case Morrison v. Olson had defended the appointment of special counsels, calling them inferior officers and not officers. W. Neil Eggleston, who had served as counsel to President Obama and is now a lecturer at Harvard Law School, says of Cannon's ruling that it's a mashup of statutory analysis and two constitutional principles, the Appointments Clause and the Appropriations Clause, and mixes them up into a new brew. He says that at once she looks at the provisions in the order appointing Smith that set forth the statutory basis for that appointment, and then she looks at the statutes and concludes that the statutes do not authorize the Attorney General to appoint a special counsel. He says that's because she claims that Smith was not a Department of Justice employee or an officer at the time of the appointment. But then wonders, it's not clear to me why that matters because today he's a Department of Justice official. And Eggleston wonders at the pretension of District Judge Cannon to attempt to overrule the Supreme Court when he says that one very surprising thing is how Cannon deals with the Supreme Court precedent in United States versus Nixon. There's a sentence in that 9-0 opinion which resolves this issue entirely. The sentence says that Archibald Cox, who was one of the prosecutors of Nixon, was appropriately appointed pursuant to the statute. And you would have thought that that would have ended this inquiry. Cannon does something I think I've never seen a district judge do before, which is that she looks into the history of the Nixon case, decides the issue wasn't particularly briefed, and as a result determines that a sentence in the Supreme Court opinion that was decided 9-0 was in fact dicta, which means that it is not binding in subsequent cases as legal precedent. As a result, she, as a district judge, was entitled to disregard it. I've never seen a district court conclude that a portion of a Supreme Court opinion is not binding, and that was a first for me. Judge Cannon gets lost in her own arguments. She at once deplores today's independent counsels, such as Jack Smith or Robert Mueller, and then lumps them into her arguments about side issues of funding or titles as proof of the unconstitutionality of special counsels going back to the Nixon era. And weirdly, she seems to know that she's wandered down a rabbit hole with her arguments when she shows how obsessed she is about Nixon in her ruling. She mentions him almost 100 times. And as though this ruling is normal, she invokes a clever dictum from an early 70s SCOTUS ruling that Congress does not hide elephants in mouse holes, even as she attempts to cram an elephant and a whale into her interesting argument that independent counsels or prior special counsels are no longer constitutional, although they had consistently been advocated to be constitutional for 50 years prior. She also attempted to thwart any appeal, not merely by dismissing the case, but calling it moot and terminated. This tactic only goes so far. Special Counsel Jack Smith's office has filed a notice in Florida court indicating their intent to ask the 11th U.S. Circuit Court of Appeals in Atlanta to overturn the July 15th ruling by Judge Cannon. And Attorney Eggleston says of that appeal that an appeal in the 11th Circuit would take roughly a year to decide. If Trump is elected president after his inauguration, he will certainly order the Department of Justice to dismiss the federal case against him. The Department of Justice would then dismiss those cases and there would not be an appeal. Now, if Trump is not elected, there's a strong chance that the 11th Circuit will reverse Cannon's decision. Whichever way the 11th Circuit ruled, he says that I suspect the issues would then be decided in the Supreme Court, and I'm not going to predict what the Supreme Court would do. Thanks for watching, and don't forget to like, share, subscribe, and look over here for more in-depth analysis, and I will see you in the next video.